Hey everybody, Zach Wolf here with another great Top 5 Tuesday. This week on Top 5 Tuesday, working from home edition, it's the top 5 tips for the defendant in a non-compete TRO hearing. Last week I talked about tips for the plaintiff's lawyer in a non-compete TRO hearing. So now I'm doing the flip side and talking about what you should do if you're the lawyer trying to defend against someone who has asked for a TRO to enforce a non-compete. Number 5 is to understand and be prepared with the case law to show that a contractual stipulation to a non-compete is not necessarily enforceable. Most non-competes are going to have a clause saying that if you violate the non-compete, that the employer is entitled to get injunctive relief or a temporary restraining order. So if you're on the defense side, you want to come to the courtroom prepared with the case law in Texas that says that's not necessarily dispositive. The cases tend to say that it's up to the discretion of the judge whether to grant a TRO. My number 4 tip for the lawyer defending against a non-compete TRO is to watch out for vague language in the proposed temporary restraining order. A lot of times the plaintiff's lawyer will draft an order that's not that specific about what the defendant is or is not allowed to do. So for example, if it talks about customers who are off limits and describes them in very general terms, you want to attack that as being too vague and lacking in specificity. That's a simple and easy way to show that a plaintiff's proposed TRO is improper. My number 3 tip for the defense lawyer who is opposing a non-compete TRO is come to the courtroom prepared with some proposed dollar amount for the bond. A TRO generally requires that the plaintiff pay a bond to secure the TRO. So what you want to do if you're on the defense side is talk to your client about how much dollar amount of business the defendant stands to lose if the TRO is granted, and use that number to argue for a specific dollar amount of the bond. Don't just make that an afterthought. My number 2 tip is also about preparation. If you're defending against a non-compete TRO, you want to come to the hearing prepared on the facts regarding the alleged competition between your client and the plaintiff. This requires consulting with your client about the details. You need to understand in what ways are they competing with the plaintiff? In what ways is their business different from the business of the plaintiff? You want to be able to understand those specifics so you can point out those distinctions to the judge. And finally, my number 1 tip for the defense lawyer who is opposing a non-compete TRO: you need to come to the hearing prepared to make your best argument for why the proposed TRO is overbroad under Texas non-compete law. That means understanding the basics of enforceability of a non-compete under Texas law, and then applying that to the specific relief that the plaintiff is asking for. You need to be prepared to explain why the scope of the proposed TRO is too broad. So even if the judge is persuaded to grant a TRO, hopefully you can at least get the scope of that TRO narrowed to something reasonable. Okay, those are my top 5 tips for the defense side arguing against a non-compete TRO. If you like this video, please hit the like button or share it with a friend. If you've got a question or a comment, let me know. And hey, thanks for watching.